We're talking about pre-mediation, the process and steps today. This, at its very simplest, is what we're trying to do in that pre-mediation process. Establish informed consent. So for me, it really is important that clients know what they're entering into. And often, depending on your context, you're going to have people that have been told to come to mediation. They're there and they might not know a lot about why they're there. Risk and suitability screening. Mediation isn't appropriate for everyone, or it isn't appropriate right now for everyone, and then helping them to prepare. The way we're teaching it is as a process, a sort of 5-step process. It's structured but flexible. So the first thing is very much the same as with mediation. Our opening statements, explaining the session, explaining the agreement to mediate concepts. Generally, my recommendation is that you get the agreement to mediate either signed at the pre-mediation with the clients, particularly if they're not very sophisticated going through with them, or you send it to them beforehand. The reason is, in a way, we're contracting the confidentiality of the process so that everyone's very clear that they're not going to subpoena you to go and give evidence. In standard mediation, we're relying on Evidence Act and convention rather than necessarily legislation. In family law, there's legislation that protects the inadmissibility of the mediation process, but in other contexts, it's more the standard law convention. Usually mediators aren't required to give evidence and our confidentiality is protected, except for those exceptions that we have. But just getting a signed agreement where the parties are agreeing to that as well helps. Any questions or thoughts about that? That's pretty clear. It depends on your context as well. So if you're doing commercial disputes, often you'll see in the agreement to mediate, the mediator will put in costs. If you force me to give evidence, it's going to cost you this much as another deterrent. Once we've done that, and as you know, it can mean that the mediator's talking a fair bit, even though we're checking in with the parties, and in the case of pre-mediation, in with the party, it's still a lot of information. So what we recommend is the next step is to just briefly get a feeling for what the issues are. In pre-mediation, you may have very little information about these people. It depends on your context, but in training, you've got a little brief page with some basic background information. So we're wanting to try and help them to download the key issues, but not going in too deep. A bit like when you're doing the parties' opening statements. You're asking enough to get an understanding of the context, the issues, but not going too deep. Then the next step is to try and get a feel for, is it appropriate? You've got some context, exploring risks, identifying what are some possible issues that might arise, explaining to the parties what the mediation process would look like, checking with them if there's any modifications that might need to be done. Then the negotiation preparations, discussing the issues in more detail. So you've made some very brief notes about the issues. Now you're going into more detail, trying to kind of tease apart a little bit under the issues for the needs and the interests that are there, exploring their expectations. Have they had legal advice? Have they had advice from HR? What do they know about their options? You might be talking a little bit about their whatness and their batness. What's the worst alternative if you can't resolve things in mediation? What do you think is likely to happen? If mediation isn't successful, what's the next step for you in other preparation? Then summary and next steps. Recap. There's been a lot of conversation, a lot of information, so you're wanting to gather it back up for them. In this negotiation preparation stage, you would have been helping them make some dot points, maybe ask some questions that they want to ask their lawyer if it's in that sort of context, maybe getting some information about procedures if it's within a workplace context. So you want to do a little reminder, bring that all back together for them and discuss next steps, confirm your confidentiality and close. Any questions or comments? Welcome, Rima and Sasha. It sounds pretty simple, but having a little bit of a process like that, it helps prevent it from turning into counselling, if that's your kind of background, or into an investigation, if that's your background, or you trying to solve the problems, if that's your background. So it's very much on helping them to understand their situation. Why do we do these intake interviews? One is capacity. So we want to determine the client's capacity to participate. So their issues. Is there drugs? Are there vulnerabilities? Is there trauma? Are there mental health issues? It's not you diagnosing, but it's looking at, are they understanding? Will they need a support person? What are the issues? In workplace mediation, often there are mental health issues. People may, often the mediation is around return to work after there's been a psychological injury and people have had time off work for that. We need to determine if the dispute's appropriate for mediation. If there's been a legal action, it may not be appropriate. We don't negotiate breaches of the law or what have you. And we want to support self-determination. So unless we prepare people for mediation, we're throwing them into a process where they're having to make decisions without proper preparation. Sometimes, particularly in workplace conflict situations, the pre-mediation's done in the morning and the mediation in the afternoon. I personally don't think that's a good model and wouldn't encourage it. It is done at times for logistics, but it's ideal if people have time to think things through before the actual mediation. And ideally, what we've done is help to prepare them for collaborative negotiation when they get to mediation. As you remember from the theory, with collaborative negotiation, people are thinking about their needs, but also the needs of others. So we might have a conversation about, what do you think the other person wants? What do you think they may need from their situation? So in the practice sessions, we've got practice sessions on Thursday. Hopefully you can make it. It's between 12 and 2. We'll do some role plays. If you're not on the AMDRAS course, if you let us know that you want to come, we'll make sure that you've got a copy of all these documents. So generally, you'd use an agreement to mediate. When I first started out, I'd use a checklist document for my opening statement so that I was able to sort of have a little crutch to keep me know that I was meeting my obligations, but also it gives the opportunity to, and clients are fine with that. They're fine with you using a checklist. I mean, pilots use a checklist. It's a professional thing to do. You can also use your agreement to mediate. If you do that, I encourage you to have nice bold headings, because then you can kind of use your headings as structuring for those, for guidance. It's common convention in mediation that we use our intake form for notes. So unlike some other roles, like lawyers often will just use a blank pad and make notes there. As a mediator, the normal process would be that you do use an intake form, and that allows us to make sure that we've been thorough and also to quickly find information later. Sometimes there might be a gap in time between the pre-mediation and the mediation. You want to just refresh yourself before the session. Risk screening, usually in context other than family law, that's just part of your intake form. In family dispute resolution, they may use a separate risk screening process. Usually you use your intake form for notes, because your notes are only really just to determine is it appropriate, prepare, and help you to refresh yourself before the mediation. They're not serving any other particular reason. If you need to do referrals, you're going to put notes about that, and generally these days referral lists are electronic, so you can usually look things up, or you might have other resources. Depends on your context. So once you're out in practice, you'll generally have that contextualized to the type of work you do. With the feedback tool, what we're looking at is those 5 stages I've just gone through: your opening statements, your introduction and your explanation, engaging the people, understanding the issues, managing the flow. Generally, I find when people get to pre-mediation, it's the first time someone's just like really ask them about what's going on, and you'll usually get a deluge. It's managing the flow of information. So like the parties' opening statements, we're wanting to find across the board what the issues are without drilling in too deep at this stage. Screening and process preparation, party preparation, and then summary and your next steps. What we're looking for in terms of your facilitation is providing support for agency, client decision making, self-determination, and again, that informed decision making. So really important part of the process in helping people to be ready for mediation, providing the information you need to provide under the ethical obligations that you have, and the various domains, engaging the parties, but remaining in your mediator roles. One of the things to be careful of is not to get out of role so much that the people think you're their best friend and you're on their side, so that when you step into the independent role of the mediator, they get a real distress in you've changed. We need to be friendly but not their friend. That management of information, helping them to prepare, understand, and get ready. Any thoughts or questions about that?
So I haven't gone through all my documentation clearly. Do we create our own checklist, or is there a checklist in the course information for us?
There's a run sheet there. I'd reduce that down. The same thing with your role plays. There's that run sheet, but it's too big. Anyone who's tried to run the mediation with the run sheet, it's easy to get lost. It's good to reduce down as much as you're able to a checklist or a process flow, just with those little prompts. It's always refining down until you're pretty much down to just your process flow, and then over time you probably won't even need that. I still go through the agreement to mediate with clients because I might have done it a lot of times, but they haven't. It's easy to gloss over things if we're not careful. And then we've got the feedback sheet again, which is the key points in there, and there's example agreements to mediate, and there's a couple of different examples of intake forms. So the intake form, you'd vary based on the type of mediation because there's different sorts of questions you're asking. So, a neighbour dispute is going to be different to a workplace dispute because, in workplace you've got the context of the other people and reporting structures. The mediator's opening statements often need a conversation around voluntary participation. So we very blithely say, oh, mediation's a voluntary process, but often for clients it doesn't feel voluntary because there may be consequences if they refuse to participate. They may be required by a court or other authority to attend, but it's always voluntary for them to agree. They can't be made to agree. The mediator never has the authority. So that's what I'd encourage you to focus on. If they can end the process at any point, you can as well. No one's trapped. This is a good chance to try and resolve things, but if it doesn't resolve things, they're not locked in. It is a confidential process. So any offers or proposals they make can't be used against them. All of those are things to stress, particularly if you've got someone that's sort of,
yeah. Two questions. The opening statement here looked very similar to the opening statement of the mediation session. So I mean, would it be comfortable to say that I could use a fairly similar script and be much covered?
Yeah.
Great. That's one more thing I don't have to learn. And the second, I did have a situation where one of the role players, just to test me, said work forced me to be here. It does lead to the question around when it's court ordered. If they turn around and say it is court ordered, I'm forced to be here, what is the correct response? Where you can still back out of that process and the court will take a subsequent action based on that decision? Is that the right advice to be giving them?
Absolutely. However, the thing I will really want to point out to you is that it's totally up to you what you agree to, or even if you agree to anything. You can't be forced to agree to anything. However, if you can't reach an agreement, then the court may be required to make a decision for you. So this is an opportunity for you to really take control of your own destiny. Just focus, pretend, we're changing perspective. So they may be coming in resentful about, oh, I'm being ordered to do this thing. And they may have illusions about the kind and wise judge will hear my story and make a decision in my favour in the court.
Yeah.
So this is wasting my time. In pre-mediation, if I had someone like that, I'd be wanting to do a lot of reality testing when I get to that fourth stage of helping them to prepare. And, you know, what do you think is going to happen if you can't reach agreement? You know, what's your advice about? And often people will only hear the best case scenario from their lawyer. They won't hear the other, so we have to do a little bit of, what if, you know, what do you think the other person's lawyer said to them?
Can you mention cost? If you don't want to participate, that's fine. This is an opportunity to take control of your destiny and play a part in the outcome of the matter to your satisfaction. But if you don't, and that's absolutely fine, it proceeds on to court, I suppose you have to consider the cost, the further cost.
Absolutely. Yeah. So there'll be a mention that it goes back to, there might be a directions hearing or a couple before the final court hearing. So there's, you know, click, 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 click in the thousands of dollars. So asking a question of, have you got a good idea of what it's going to cost you from here to...
Also, I suppose on that, I have to go in a few minutes, but I just wonder if, like, let's say it's a neighbourhood dispute. One of my concerns is if I was a mediator, I wouldn't know what the next steps are to warn them against them or to bring it into reality tests, like, you know, to sort of say you don't have to participate, but this is your opportunity to take control. And if you don't participate, then maybe, like, I don't know the next steps.
Yeah, so you can ask them in the role play, what do you think the next steps would be? The next steps can be do nothing and live with the conflict. It can be, you know, we won't talk to each other is a really common thing that people decide. So they never have a word with the next door neighbour if they accidentally come out together, or they may take it further. They may be forced to take it further. You can throw it back. If you don't know, later when you're in practice, you'll make it your business to know. It'd be ideal to visit your local magistrate's court and see what they do there. Or if you're doing neighbour disputes, that's normally where they'll end up. Also make friends with some local lawyers, so you've got a bit of a brains trust. That can help as well. I will put the presentation up, and if you've got some more questions and you can make it on Friday, feel free to bring
them. I'm going to try and make it on Thursday, actually.
Oh, excellent. That'd be great.
Yeah.
You can be a role player first and then jump in and have a go. I'll just watch.
I'll let you know this afternoon, I suppose. Yeah. I'll try and,
it's just a practice.
I know it's all really good learning. I have to go now. Thank you very much. I'll look out for the recording.
No problems. Take care.
Bye.
Excellent. And you're correct, Colin. It's very much the same information. Generally, we'll go a little bit deeper in this session. In real world mediation, you tend to be a bit more superficial because you've already gone through it with both of them. So you're just reminding them. In the assessments and that sort of thing, we get you to do it more thoroughly because that's the first time that making sure you know what you've got to say and you're giving the right information.
Yep.
If that makes sense.
Yeah, totally.
So understanding the issues, again, we can think about some of the theory around conflict. So causes of conflict, lack of information, poor communication, values differences, social disparities, structural inequalities, different interests. So these are from Moore's conflict tree, given it roots. Generally, conflicts are a tree rather than a carrot. So there's various contributing factors, but we're listening for what the issues are, but we're thinking, well, what's that an example of? Is it sounding like there's misunderstandings? Maybe there's some information missing. We might ask questions about, oh, have you talked this through with them? Oh, no, we don't talk. I reckon there's some misunderstandings going on there. So that when you get to the mediation, you're going to be really focusing on that in the exploration. In this course, in this training, when you're doing mediations, you're doing it a little bit with a hand behind your back or maybe a blindfold on because you haven't had that opportunity of the pre-mediation to have a bit of a feel for where you may be needing to go through. At this stage in the pre-mediation, we ask them to tell the story. Generally, we're going to give them a chance to just tell us, and it can be quite detailed or confusing. So we're thinking about chunking up. What are these little stories? What are they an example of? If that makes sense. So we're trying to understand what are the issues driving the conflict. If we can understand what are the issues driving the conflict, that might give us an idea of where we can help them to change the perspective or fill in those information gaps or think about what, are there power imbalances that are causing the issue. Some of those things are there and they're not going to change. Other things are absolutely able to be resolved in the mediation process. But again, I'm stressing when we're doing the pre-mediation, we're like parties' opening statements. We're trying to be superficial here and kind of get the breadth of the issues rather than drilling down really deeply, if that makes sense. So it's an invitation to explain their issues, framing expectations. If you don't frame it and say, I want you to tell me about the issues, they've got this opportunity to talk and they're probably going to take it unless they're a very non-talking person. Again, we're asking our open-ending questions. We're doing active listening and checking our understanding. The facilitation skills that you're using is that framing, asking those open questions rather than, trying to lock people into where we want them to go. Using active listening, so clarifying questions, summaries, checking in, all of that. And we're trying to get a little bit of an understanding of the positions, interests and needs that are present there. Any questions as we go? No? Pretty simple. So risk and suitability screening. So this is where we may go more deeply into, so lack of volunteers. So people might make a little bit of a grumbly comment when we're going through the party's opening statements. We might revisit here a little bit more now we've got some context, because we didn't have any content before. We've met this person for the first time. We're dumping a pile of information. We don't know the context. Once we've got some more context from there, the explanation of the issues, we can provide better response. Has there been violence, threats or coercion? So, if there has, we may be thinking, well, I don't feel comfortable facilitating mediation. This is not appropriate. Or it may be that sometimes people see a request from someone as a threat. Just someone asking for something can be, oh, they're trying to bully me into something. No, they just asked you. You can say no. If they're in a situation where they can't say no, that's different. That may not be appropriate. If you're trying to tell the difference, you might say, what would happen if you said no? Nothing, I guess. Okay. I'm comfortable with continuing. So they'll do this or that, or history of broken agreements. So is that going to be a factor? Have there been many attempts and it's not going anywhere? So if that's the case, then we know if we're going to mediation, we're going to have to go a lot deeper. People are saying they're going to do something and then it means they haven't got to the bottom of the issue. Legal and safety consideration. If there's a personal safety intervention order, we can only mediate if it allows it. We need to think about what is being negotiated. The same if there's court orders, how do they implicate? It's really important that you see those documents. You can't proceed to mediation if orders may be impacted by an agreement without understanding what they are. Power imbalances and hostility. Is there a lot of anger? How's that going to be managed? And that's where we'll be talking about the standard approach to mediation. How would that be for you? How do you think you'd cope with that? Are you going to be able to speak directly? Are there any unrealistic or not negotiable positions? Are they seeking punishment? It says that I'm not that great on punishment. It's possible that there may be apologies. That can certainly happen in mediation. Is that still going to be something that you'll find useful if you can get some understanding and perhaps acknowledgement of harm that you feel has been done? And hopefully they'll say, oh yeah, I'll see. Yeah, so this is what that risk and suitability screening part is all about, really trying to understand what are the factors, are they going to mean that our process is not going to be safe or not going to be appropriate. With many of us working online now, the risks of bringing people who are potentially volatile into the same place is much less. I've been very lucky. The worst I've had is someone just like throwing their pen across the room in an upset situation. Others have had worse, but that tends to not bother us if they're doing it from the comfort of their own home on screen. My approach is always to talk to people about it. How are you, if they're talking about volatility, how do you think you're going to cope? We might go through Once we're talking about the process, we'll go through ground rules. Do there need to be any others? So generally your ground rules or behaviour protocols will be developed based on the pre-mediation and what you think might be an issue. If someone says that they just go on and on, I can't get a word in your mediator's opening statements, when you get to the mediation, you might talk about, sometimes I'm going to need to interrupt you and I'm apologise for that in advance, but if necessary to keep the process flowing and manage our time, I will do that. Is that okay with you? So that you've got permission if we've been pre-warned that someone's like that, or after our experience with them at the pre-mediation, we know they're like that. So this is our decision. So proceed with mediation. We think it's suitable. There's no modifications needed. This is a decision we're constantly making. The dynamic we see in a pre-mediation can be completely different once they get together with the two people. This risk and suitability screening is an ongoing process that we do. We may need to modify to address specific concerns. Maybe we're going to use a shuttle process. Maybe we're going to either invite or require support people, depending on the context. Maybe they need lawyers there. There's all sorts of reasons. Or we may think that this isn't appropriate. You need a different process. So that's what that risk and suitability screening. Does anyone have any questions about that? No, it's all pretty straightforward. Yeah, so it's just a bit of a dynamic. And then the preparation. So there's a whole lot of different things that we can do here. We won't necessarily do everything with every client. We might explain some context. I used to often draw a diagram of different things. If I was picking up their conflict styles are very different, I might draw the conflict styles diagram and talk to them about the need to shift the way they normally deal, share what's important to them if they've got an avoidance style. So it's up to you. You might have some favoured models or diagrams that you like to pull out for people. Again, the BATNA and WATNA and what a compromise, or what are somewhere in between the worst, best and worst, what can they live with? So all of that sort of language we're starting to try out with people so that they understand that there's not going to be an agreement unless what's proposed is acceptable to both of you. That's the bottom line. We've already talked about the fact that as a mediator, my role is to facilitate a process, not to force either of you into something that you don't find acceptable. So that means you need to be willing to listen to what they've got to say and what they need, and also be willing to share with them what you need. Do you have any concerns about that? What can I do to help you to prepare for that? If there are external factors, are there other people involved? In a commercial situation, is this even the right person? Do they have any decision-making powers? Sometimes someone's sent with a position up front and they don't have any negotiation ability. It's wasting everyone's time. If that's identified, if something new comes up in the mediation, how can that be dealt with? Are you able to call and get authority? Will we need to put the mediation on hold so that you're able to speak with the committee? Whatever that might be. This is an opportunity for you to prepare so that you're not sideswiped in the mediation where they say, oh, I've got no authority to agree to anything. What am I doing? I'm wasting everyone's time here. Because if the mediation was going to resolve with what they come in with, then why would we have a mediation? It would have been sorted by a letter. This is often talked about as the mediator's toolkit, all the different ways that you can help people look at things and prepare for mediation, preparing for legal advice or negotiation, sometimes helping people realise they don't know enough about their situation and that they need to get some information before the mediation can be really helpful. Well-informed clients make our job a lot easier. People with delusions that are impractical are not able to do things in their own best interest. What we're looking for in terms of skills and process is really clarifying, helping the people to really clarify their issues and discuss expectations. So some people are overwhelmed with the detail, and others, they're thinking at too high a level and they're not looking at what would need to change, what is the detail. And we've all got different levels of abstraction of thinking that we're comfortable with. So sometimes we might need to help people to look at things slightly differently. Worst case, best case, if they don't reach agreement in a negotiation, any legal or other advice, assisting them to consider their options, And then with our facilitation, again, asking open-ended questions. So we don't need to come up with a solution for them. But all we need to do is help them to think about, be very clear about their issues, identify if there's gaps in their understanding about their options, and maybe get some assistance before that, help to kind of shake up a little bit their positional thinking about what they want, why they want it, how they could get it, what it looks like, and all of that sort of thing. And then that final stage, we often get, okay, we're finished. We want to bring everything together for them and put it in a box and put a bow on top so that they can take that and do their preparation before your mediation session. Providing a clear summary of the key points of what we've talked about, any process necessary to schedule the mediation. This will vary a little bit depending if it's the first person you speak to or the second. Confirming the confidentiality, reminding them you're able to speak with professional or personal advisors about mediation processes. I definitely encourage you to do that preparation. Remember, the mediation is a confidential process. Confer any referrals, party homework. So hopefully if you've done a good mediation, there's some things for them to do, or a good pre-mediation rather. Answer any questions, confirm the next steps, and send them off. There's a run sheet in the AMDRAS course. If you're not in the AM course, contact the office and ask for a copy. Happy to provide that for you. The preparation, the logistics, confirming all of that. If you're doing it in real life, the considerations are privacy. If you're within an organisation, making sure you're not in a fishbowl office with everyone looking and saying, what's going on there? What are they doing? And just make sure you've got all of your tools ready. Oh, yeah, just a bit of timing and that sort of thing. Pretty much repetition of what we've talked about. Screening process, negotiation, preparation. So ultimately, we're trying to encourage more flexibility in thinking. So again, from conflict theory, we know when people get in conflict, they can become very fixed and rigid in their thinking. It may not be their natural state, but in this conflict situation, it's common. That's what happens to us. So part of what we're doing is helping them be a little bit more flexible, and that's good preparation for the mediation so that they're already coming with some ideas they can talk about together. As I said, we've got various different intake forms. Once I know who's coming for the session on Thursday, we can have the different forms, whether it's a workplace, community, or a neighbour dispute that you're going to do. We're not going to do any complex commercial ones. They tend to be a little bit more structured. Usually there's lawyers involved and it's more of a settlement conference, which is slightly different. Usually parties will present position papers and things like that rather than turning up not much of an idea of what the hell's going on. But someone said they should come. Colin, does that all make sense?
Those other run sheets, are they on the?
Yeah, they're in the COT, the CV of training, in the files area for the
Pre-mediation.
You've got the run sheets and scenarios.
You've got the one run sheet, but not the different ones
No, they're
for.
the intake sheets. Look for the intake forms. Process is the same. It's just the questions change a little bit depending on the context. So that's where you've got the different intake forms. Does that make sense?
Yeah, cool.
Yeah.
Awesome. And just a question, I suppose, a little bit more around the sort of, I suppose in terms of the sort of whatnot, batna kind of stuff in practice, I tend to feel that the worst alternative tends to be a bit more of a stronger reality check. I mean, isn't people's natural tendency, the best alternative is I'll just get my way and everything will just fall in line, How effective is that really as a tool?
It can be if people are overly optimistic, because we
Yeah,
can say, oh, well, I'll just get my way and everything will be fine. And you say, oh, that's interesting. What are you basing that on? What's feeding those expectations?
yeah,
So we can kind of question what's underpinning that optimism
yeah,
at times. So that can be helpful because people can just, oh, it'll be all right.
Yeah. Okay.
It's really looking at, is there unrealistic optimism? And it's not up to us to give advice. What are you basing that on? I'm not
Yeah.
questioning the thing, but I'm just curious, have you had advice to that effect? Oh, I looked it up on ChatGPT. Oh, okay. I love it too. However, it's not always accurate. Sometimes it can make things up. And the worst case, it can help to get people really focused on, I really need to get this resolved. I can't sleep at night. It depends on the people. If they can't sleep, so what are you thinking about at 3 a.m. in the morning?
Hmm.
That can identify anxieties, things they're worrying about that haven't happened.
Yeah.
Are they realistic? Because sometimes people can have an overly pessimistic approach as well.
Yeah. Right.
And that usually their expectations of the other people are fueled by the conflict, and so there's a dark overlay over how they see that person. Sometimes we can remind them, did this ever work with the other person? Are there glimmers of light that perhaps you could return back to a better
Yeah.
situation? They're useful tools, and we're just trying to open up, get them out of a fixed position and considering options and thinking more openly. Not any particular set outcome that we're trying to engineer, because we don't know enough about it. If this is the first person, we've got no idea how the other person's going to present.
Yeah.
Even if it's the second person, we've got no idea how they're going to interact in the mediation. We don't know enough about their life to know really what the best outcome is for them. So
Yeah.
stick to our lane, facilitate.
Yeah, for sure. Thank you.
You're welcome. Hopefully that was helpful, and to my little silent watchers in the background.
I thought I'd be a friendly face for you. Cool. So I'll see you tomorrow is the session. I booked
Thursday.
Thursday. Yeah, I know. Perfect.
I'll send you a link. Sounds good.
Perfect.
See you
Okay.
then. Take
Cheers.
care.
Bye.